be safe to just give one more minute for people to join in, because I'm seeing that there's still quite a few people who are joining the webinar. So we'll just give it to 09:33 and then we'll begin. Business rescue in relation to small businesses. And the presentation is going to be given by Juliette de Hutton. Juliette de Hutton is she's a partner in our dispute resolution office that's based in Cape Town, and she specializes in liquidation and business rescue and debt restructurings. She will be giving this presentation today with Daisy Fakude, and Daisy is a senior associate in Juliette's team. So before we begin, I just wanted to run everyone through a few housekeeping matters. So just as a point of departure, everyone is going to be automatically muted. So if you are an attendee to this webinar, you'll be automatically muted and your camera will be off. So the only cameras that will be live during the session will be Daisy's camera and Juliette's camera. However, should you want to ask any question, you're more than welcome to ask any question during the presentations. Please make use of the Q&A tab, which should be at the bottom of the screen or everyone's camera projections. So just at the bottom there's a tab that says Q&A, and you're more than welcome to just place a question there. I will make note of your question, and depending on the urgency and the relevance of it at the time of the presentation, I will either ask the question to either Juliette or Daisy, or we can wait towards the end where we can have a Q&A session. However, I think it would serve us to have more of a discussion or dialogue during the presentation. And for anyone who's also attending this presentation, please note that we are recording this, and in the event that there might be a few points that you might want to revisit at a later stage, we will post this whole presentation on our website at www.bowmanslaw.com. So with that, we will begin. Welcome Daisy, welcome Juliette, and good luck for your presentation.
Thank you. Thanks, Linda. Hello everyone, I'm Juliette de Hutton. We're going to divide the presentation into two sections. I'm going to start off by talking about liquidations, and Daisy after that will talk about business rescue. We are, as Linda mentioned, happy to take questions as we speak if it's something you particularly want to ask. If it's of a more general nature, probably better for it to wait till the end. Okay, so liquidation and business rescue are both quite hot topics at the moment. Obviously, as a result of COVID-19, there are many businesses out there that are financially distressed. I hope that none of you are in a situation where you're faced with either liquidation or business rescue. But the purpose of this presentation is really just to give you a sort of a high-level overview of those processes. You might find yourself faced with liquidation or business rescue either in the context of your own business, or perhaps if you are a creditor of another business that is facing one of these scenarios. So first of all, to talk about liquidation. Now that obviously is the most dire scenario a business can ever face. It's a process designed to bring the company's existence to an end. And essentially what happens is all the assets of the business are going to be sold off, turned into money, and the proceeds of those assets are then used by the liquidator to pay creditors as much as he possibly can in their order of preference. And we will talk about that order of preference a little bit later. A couple of important concepts to understand. First of all, I want to make sure everyone understands the difference between factual insolvency and commercial insolvency, because people talk very generally about insolvency, but there is a difference between factual and commercial insolvency. Factual insolvency means that your liabilities exceed your assets. Commercial insolvency rather refers to a situation of illiquidity. So it's when you're unable to pay your debts as they fall due. So you might be factually solvent or insolvent, but still be commercially insolvent. In fact, there are many businesses out there that carry on under a factually insolvent state of affairs for a very long time. So their liabilities might exceed their assets, but they still have the cash flow to keep servicing their debts as they fall due. So those businesses are absolutely fine. The test one needs to look at and assess whether a company needs to be liquidated is when you're illiquid. So you can't pay debts as they fall due. And that's essentially what a court or a company that needs to look at whether it goes into liquidation needs to assess. Can I pay my debts as they fall due? If you can't, you are in a position where you probably should be going into liquidation or considering possibly business rescue, which we will address after this. Now, there are two ways a company can be placed in liquidation. It can either be a voluntary process or it can be a court-imposed compulsory process. If we're looking at a voluntary scenario, that would be where the company, the shareholders of the company, pass a special resolution to put the company into liquidation, and that resolution can then be filed with SIPC, the Companies and Intellectual Property Commission, and liquidation then follows. The alternative process where a court puts a company into liquidation, that can either be as a result of the company itself initiating the process, or it could be a more hostile process where a creditor or a shareholder initiates that liquidation process. And again, that would be generally on the basis that the company is unable to pay its debts as they fall due. So it's commercially insolvent. If it is an application that's done in court, it can be done pretty quickly if it's unopposed. What happens is that the person bringing the application would sign an affidavit in which they swear under oath as to the relevant facts. They'd set out why the company is commercially insolvent and should be placed into liquidation. If it's going to be an opposed application, so if, for example, a creditor brings that application and the company opposes, that would generally be a longer process. It could stretch over a few months. Before a liquidation application is heard in court, a copy of that application needs to be given to, first of all, the company in question, second of all, the employees of the company, thirdly, any trade union representing employees, and fourthly, the South African Revenue Service, because as we all know, SARS always wants to make sure that they get their slice of the pie. And then once the liquidation application is heard in court, let's assume it's unopposed or is opposed, but ultimately it's heard by a judge. The court will generally, in most divisions of the High Court, and when I talk about divisions, you obviously have the Western Cape Division, you have the Gauteng Division. If different parts of the country are serviced by different courts, they will generally first put a company into provisional liquidation, and then a return day is set, often 6 weeks or so after that provisional order, where anyone who wants to come back to court and explain to the court why it shouldn't go into final liquidation has the opportunity to do so. And then on the return day, assuming there are no relevant issues that are raised, a company will be put into final liquidation. What happens on final liquidation, obviously, is that the directors of the company then no longer have a role to play, and a liquidator will step into the shoes of the board of the company and regulate its affairs from then on. How is a liquidator appointed? They're appointed by the master of the High Court, who is the sort of the bureaucrat, the government official who's responsible for overseeing liquidations. And liquidators are appointed on the basis of support from creditors. So they approach all the creditors of the company. They try to find out who they are. They approach them and they try and get those creditors to sign what are called requisitions, which are really nomination forms supporting them. So often if, for example, there's a bank who's a significant creditor, the liquidator will end up being someone who that bank has supported and nominated to be the liquidator in question. In most cases, companies are given 3 liquidators. So it'll be someone who the biggest creditors in value support, someone who the biggest number of creditors support, and then often there's a previously disadvantaged individual appointed as an additional liquidator as part of the transformation process, which is being spearheaded by the Master of the High Court. After that, the Master convenes the first meeting of creditors, where the creditors can come and prove their claims, and that's done by a form where you fill out and you certify under oath what the company owes you, and then those all go through to the liquidators. Final liquidators are also nominated at the first meeting. There's also a meeting of the shareholders generally held also to nominate final liquidators. And then further creditors meetings can be held down the line where creditors have further opportunities to, first of all, prove their claims, and then also to give directions to the liquidators as to things that they would like done. A liquidator needs to have powers to act, and he either is given those powers by creditors and shareholders, or there are circumstances under which a liquidator can approach a court to obtain the powers he needs. And that would include the powers to sell the assets of the company and to then use those funds to repay the creditors. Various things happen when a liquidation order is granted. So the first is the concursus creditorum, which is really just a fancy Latin term for the freezing of the company's affairs. So it's an axe falls at that moment and the position is frozen. No creditor can take any step to improve his position vis-a-vis any other creditor. The trading of the company obviously ceases. It closes its doors, except in very limited circumstances, which I'll mention just now. Employees are suspended, and unless a liquidator is going to use any of those employees to help him wind up the company, their employment will automatically cease 45 days after a final liquidator is appointed. In respect of contracts that the company hasn't completed, those don't automatically terminate. The liquidator has to decide whether he wants to continue with those contracts or not. And he will do so in the best interests of the general body of creditors. So let's take an example of a company that goes into liquidation. It's a garment manufacturer, a clothing manufacturer, and there are some items of clothing that are half made. Only a little bit needs to be done to finish off those garments and deliver them to a customer, client, who will then pay a substantial amount of money for that clothing. The liquidator might decide to carry on with that contract to get the money in that can then be used to the benefit of creditors. He's not going to elect to carry on with contracts which will involve risk or the company incurring huge costs, because that obviously won't be to the benefit of creditors. So then really, once the liquidator is fully authorized by resolutions from creditors and members or by the court, his main job is to wind up the affairs of the company, sell all the assets, and then to distribute them. Now, obviously, that process can sometimes be quite a quick process if the company doesn't have a lot of assets. It could be quite an extensive process. A liquidation normally takes sort of a year or so, or a year or two to finalize. But of course, if it's a very complicated company, and especially if there's a lot of litigation that results, court cases, a liquidation can stretch on for a number of years. And there are unfortunate instances where the winding up process can stretch over as much as 10 years even. There are limited circumstances where a liquidator may keep trading. If you go back to that example I gave a little while ago of a garment manufacturer, if a liquidator thinks he might be able to sell the entire business as a going concern, and in that way bring in better money for the creditors than if he sold off the assets piecemeal, he might decide to continue trading. He needs to get permission to do that, either from the court or to creditors. And under those limited circumstances, he could continue trading, often with a view to selling the company as a going concern. Then creditors and their ranking. This is something people always want to understand. So there are really three classes of creditors of a company that goes into liquidation. So the first lot, who are in the most powerful position, shall we say, are the secured creditors. So these are creditors who hold security for their claims against the company. And typical examples of security would be a mortgage bond, a notarial bond, a cession of the company's debt book, a cession of shares. And those creditors are always going to be paid from the realization proceeds of that asset. So if you are a bank and you have a mortgage bond over an immovable property, some real estate, that property will be sold, and the proceeds of that property will go to you first before they go to anyone else. Only if there's money left after you've been paid in full will that money go into the pot to be shared by other creditors. If a secured creditor isn't paid in full from the asset that he holds as security, the balance of his claim is obviously not secured. It falls into the third category we'll mention of concurrent creditors. So that was secured creditors. Then all the other creditors are not secured. They all share in the assets that are unencumbered, that are unsecured. But there are two sort of subclasses there. So the first are preferent creditors, and they rank ahead of the other creditors purely by virtue of provisions set out in the Insolvency Act and the Companies Act. And those are essentially employees and SARS mainly. So they get the first bite at the cherry in respect of unencumbered assets. Now, only if secured creditors are paid from their assets, SARS is paid and employees are paid what is due to them, do other creditors who are unsecured and not preferent get any return from the assets of the company. So unfortunately, in many cases, it means that there's not a lot left for other creditors, and that's where you hear of creditors getting 5 cents in the rand or 10 cents in the rand. That's what would go to those creditors, which are generally the company's normal trade creditors. What the liquidator then does once he's realized all the assets, sold off all the assets, is he has to draw up what's referred to as a liquidation and distribution account, or normally we would call it an L&D account. And that is really a document that sets out exactly what he sold and what proceeds he got for it, what expenses he had to pay. So for example, if he sells assets on auction, he would have the auctioneer's fees, the costs of having stored the assets, the costs of insuring those assets. So he sets all of that out in the account. And in the second half of the account, he shows how those funds are going to be distributed to the creditors. And when that account is drawn up, it is advertised for inspection. So all the creditors can inspect it. They can have a good look at it. If they have an issue with it, they don't agree with what's there, they have a period during which they can object. And only once objections are resolved does the Master of the High Court confirm the account, and the funds then get distributed to the creditors as set out in the account. Now, sometimes this can be a protracted process because there might be creditors who object to an account, don't agree with what's set out in it, and litigation can ensue, and an account could then linger for months in an unconfirmed state while the litigation needs to be resolved. Something worth mentioning is that in an instance where a company goes into liquidation and it really doesn't have very many assets at all, you could face a scenario where the costs of winding the company up actually exceed what can be realized for its assets. So the liquidator has costs he's got to meet, and he actually doesn't have proceeds that he can use to meet those costs. And in those instances, what is called a contribution could be levied on creditors. So creditors, instead of actually getting something from the company, can be required to pay into the company to fund those costs that the liquidator can't meet. Now, obviously, that is a very unfortunate situation. Normally, the creditor that would then need to pay a contribution would be the creditor who brought the liquidation application in the first place. Other creditors who weren't involved in bringing the liquidation would not have to contribute unless they've proved a claim. So one thing to always check if you are a creditor before proving a claim is whether there's any danger of a contribution being levied on you in due course. What happens at the end of this process? There could be a first L&D account, second L&D account, third L&D account until all the assets are realized and distributed. Eventually you have a final L&D account, and that really brings to a close the winding up process. The liquidator will let the Master of the High Court know that the process is at an end, and the Master of the High Court then files a particular certificate with SIPC. The company is an intellectual property commission, and the company is dissolved and removed from the company register, which brings the process to a close. So that really is a high-level summary of how liquidation works. Linda, I don't know if there are any questions people have typed in that you think we should address at this stage?
Yes, so someone asked a question how, I guess, the liquidation of a company would affect the director in his or her personal capacity.
Okay, all right. So, I mean, obviously in law, we have this concept of separate corporate personality and limited liability, and generally directors are not liable for the debts of a company. There are some limited scenarios, however, where a director could be held liable, and the big one there is reckless trading. So if you, as a board of directors, allow a company to continue trading and to keep incurring debts under circumstances where you know you're not going to be able to repay those debts, you can be regarded as trading recklessly, and the court can hold you personally liable for some of the debts of the company. So if you get into a scenario where your company is illiquid and you're battling to pay your creditors, you need to be very, very careful of not incurring more and more and more debt under circumstances where you are very unlikely to be able to pay it, because essentially then you are gambling with your creditors' money, and the court looks very unfavorably upon that state of affairs, and you can attract personal liability. Other than that, there's really, as a director, there's very limited consequences for you. Your role as director ends when the company goes into liquidation. One of the things a liquidator is required to do is to investigate why a company went into liquidation. And if there is, for example, fraud that is being committed by directors or reckless trading, obviously he would need to take the appropriate steps in that regard and bring any civil claims necessary, or even report you obviously to the prosecution authorities, or the Hawks or whoever it may be, to investigate your activities. But barring that, barring any misconduct on behalf of a director, there are no ongoing consequences. We all would have seen in the press recently Dudu Mayeni and her being declared a delinquent director. That is something that also could happen to a director, not just in a liquidation scenario, in any scenario where a director behaves very badly, very dishonestly. But again, that's quite a hectic remedy that people would have to seek. And you have to have behaved exceptionally badly to become a delinquent director. And the consequences of that may be that you cannot act as the director of a company going forward, sometimes even for your lifetime. It could be for a prescribed period, but in extreme cases, the court could say that for the rest of your life, you cannot act as a director of a company. And there could also be some punitive fines, etc., that you have to pay to compensate people for your behavior. But as I said, that's an extreme case. And in general, as a director, there are no long-term consequences for you if your company were to go into liquidation.
Juliette, so just a question on my side, actually. I'm just on your point of delinquency. Does that have to be attributed to a director, I guess, intentionally, committing some acts of misconduct, or would it also extend to, like, perhaps the director not being as competent as they're expected to be, in as far as following their fiduciary duties to the company?
Yeah, I mean, to be declared delinquent, Linda, your behavior really has to be grossly negligent or intentional. I think the law accepts that people sometimes exercise poor judgment, or in hindsight don't make the best decisions. It's really in cases of extreme negligence and dishonesty that you would be declared delinquent. You can't hold people responsible for perhaps making a business decision that wasn't the best under the circumstances, unless it really is grossly negligent or dishonest or intentional or fraudulent or something along those lines. Does that answer your question?
Yes, that does. And I would assume gross negligence would kind of, to an extent, amount to some form of intention, basically.
Yeah, exactly. It's sort of a reckless disregard for the consequences of your actions, rather than possibly having an intended, negative consequence, but actually just really not caring what the result of your actions are going to be on your company, your creditors, etc. Are there any other questions we should answer at this stage?
So we do have another question. So the question states, with COVID and its implications, if the business is facing financial difficulties now, can it liquidate itself? And then after COVID, when business prospects improve, re-register the company?
Okay, look, I mean, once the company is in liquidation, that's not a sort of a reversible state of affairs, so to speak. So once you go into liquidation, you've gone into liquidation and can't really back out of that scenario. So I think, you know, liquidation, you need to have decided essentially to terminate the business's existence. You can't sort of put it into hibernation or anything with a view to reviving it later. So I think if you're going to decide to liquidate, it mustn't be something you think you'll want to change your mind on possibly later as circumstances change. It's better to close the business down. And if circumstances change, you could obviously start up a new business, which might be doing a similar thing to what your old business did, but better rather to liquidate it and avoid running into, for example, a reckless trading scenario where you keep going in the hopes that things are going to change. And that's something possibly also just to highlight is, unfortunately, people tend to be overly optimistic sometimes about the prospects of a business turning around. You sometimes really have to take a long, hard look at your business. And if there really isn't a good prospect of things turning, you sometimes need to make that tough call sooner rather than later. And certainly it can be a mistake, for instance, to encumber all of your personal assets to try and save the business. So for example, to take out another mortgage on your house to pump the money into a business, because ultimately if the business fails, you're going to stand to possibly lose some of your personal assets too. And that can have very severe consequences for shareholders and directors of companies.
Okay, so there aren't any further questions at this point.
Well, I think then should we move on to business rescue, which Daisy is going to present. Obviously, business rescue is something which won't terminate your business's existence. It's something you go into in the hopes that you can actually save the business. So it's a much more positive process, and Daisy is going to talk you through that. Thanks. Over to Daisy.
So as Juliette says, business rescue essentially provides an alternative mechanism to facilitate the rehabilitation of a distressed company. It does that by providing for the temporary supervision of the company, as well as allowing the business rescue practitioner to manage its affairs, business and property. It provides for a temporary moratorium against the rights of claimants, so creditors against the company, while the company is in business rescue, and in respect of property in the company's possession, whether it's owned by the company or by third parties. But the most important function of business rescue really is the development and implementation of a business rescue plan that's aimed at restructuring the affairs, property and liabilities of the company. The plan can either aim to maximize the likelihood of the company continuing on a solvent basis, or if that's not possible, of obtaining a better return for the creditors and shareholders of the company than they would have received if the company had gone into immediate liquidation. Business rescue is designed to be a relatively short process. So essentially, in terms of the act, it's supposed to last for approximately 3 months. In practice, however, it's often very difficult for the appointed business rescue practitioner to get on top of the financial position of the company and the business and how best to restructure its affairs and publish a business rescue plan within that period. So oftentimes it lasts for longer, and in complicated business rescue, sometimes it can last for a number of years. In order to understand the business rescue process, there's some important definitions in the same way as liquidation that you need to understand. The first would be that of an affected person. Affected persons are the most key role players in the business rescue process. So they have extensive rights to participate in the business rescue. They are essentially the creditors of the company, the shareholders of the company, and the employees, or if the employees are represented by a registered trade union, then a registered trade union will also be an affected person. The next important definition to understand is that of being financially distressed. So a company will be financially distressed if it appears reasonably unlikely, that the company will be able to pay all of its debts as and when they fall due for payment in the ensuing 6 months, or if it appears reasonably likely that the company will become insolvent. So in the ensuing 6 months, so essentially that the liabilities of the company will exceed the assets. Business rescue can be commenced by 3 people, essentially. The board of directors of the company by resolution, an affected person by applying to court for an order placing the company in business rescue, or the court itself in certain instances. So a company will commence business rescue proceedings if it files a resolution with SIPC or applies to court for an order authorizing it to file that resolution. An affected person, if they apply to court, then to commence business rescue, then business rescue will commence. Or if the court makes an order during liquidation proceedings, that business rescue would be an appropriate remedy to rehabilitate the company, or in proceedings to enforce security against the company as well. So, like I said, a board of directors can adopt a resolution to commence business rescue proceedings in respect of a company, but they can only do that if there's reasonable grounds to believe that the company is actually financially distressed within the definition that I've explained previously, and most importantly, that there needs to be a reasonable ground for believing that the company can be rescued. An important thing to consider is that the board of directors of the company can't adopt a resolution to place the company in business rescue if they are already pending liquidation proceedings in respect of that company. And even if they even if they adopt that resolution, the business rescue proceedings will only commence once the resolution has been filed with SIPC. And it's also, once the resolution has been filed with SIPC, there are very important timelines in the act that the company must comply with. So they will need to file a notice of that resolution to affect all affected persons in the prescribed manner. So, for example, by email, by delivering a hard copy. Employees would normally publish the resolution by publishing it on a notice board at the premises where the employees of the company can be found and will have access to it. They also need to appoint a business rescue practitioner within 5 days of having filed the resolution with SIPC. And then within 2 days of having appointed the business rescue practitioner, they need to file their notice of appointment of the business rescue practitioner with SIPC. And within 2 days of that notice having been filed with SIPC, then they need to publish notice of the business rescue practitioner's appointment as well to affected person. When a court considers on application by an affected person whether or not to place a company in business rescue, they need to be satisfied that the company is financially distressed, or that the company hasn't paid an amount that's due in terms of a public regulation or in terms of an employment-related matter, or if for some other reasons, financial reasons, it's just inequitable. In all 3 instances that I've mentioned, there still needs to be a reasonable prospect that the company can be rescued. If that doesn't exist, then it's the court will not make an order placing the company in business rescue. Whereas the appointment of a business rescue practitioner by the company is final. If the court appoints a business rescue practitioner, then the appointment is interim. It will only become final when it is approved by the holders of a majority of the independent creditors' voting interests at the first meeting of creditors. When the court considers an application to place the company in business rescue, they can also dismiss the application and place the company in liquidation. So that's an important consideration for an affected person to consider when applying to court for an order placing the company in business rescue, that the court could find that the company actually, even though it's financially distressed, there's no reasonable prospect of rescuing the company, and it would actually be a better alternative to put the company in liquidation immediately and allow the liquidator to take over the affairs of the company, realize their assets, and pay the creditors in the statutory order of preference that Juliette had explained to everybody beforehand. Okay, another important consideration is that once the application to place the company in business rescue has been issued, then it suspends any liquidation proceedings. So it could be that the company is already in liquidation and an affected person can apply to court to then put the company in business rescue. If that happens, then the liquidation proceedings are suspended until the court makes a ruling on that business rescue application. So as I mentioned previously that the appointment of an interim business rescue practitioner needs to be ratified at the first meeting of creditors. So that first meeting needs to take place within 10 days of the business rescue practitioner being appointed. At that meeting, the business rescue practitioner will have to advise the creditors whether or not, in their view, there's a reasonable prospect of rescuing the company. Receive claims from the creditors. And another important function of that meeting is that the creditors can decide whether they want to form a creditors committee. In larger business rescues, such as the recent SAA business rescue or EdCon, it's often quite, the pool of creditors will be quite large. So it is actually an effective tool for the creditors to form a committee that can liaise with the business rescue practitioner on the views of the creditors, and often helps to facilitate the process and make it run smoother. Within that 10-day period that I've mentioned, the business rescue practitioner also has to convene what we call the first meeting of employees' representatives. At that meeting, the business rescue practitioner will also have to advise employees' representatives. Often if they don't have a representative, like a trade union, then it will be the employees themselves, on whether they think there is actually a reasonable prospect of rescuing the company, and the employees and employees' representatives can also determine whether they would like to establish an employees committee. So the most important function of a business rescue practitioner, once they've been appointed, is to investigate the affairs of the company, and really, most importantly, to determine as soon as possible whether there's actually a reasonable prospect of rescuing the company. If the business rescue practitioner determines that there isn't a reasonable prospect of rescuing the company, then they need to inform the affected persons in the prescribed manner and apply to court for an order converting the business rescue proceedings to liquidation proceedings. Likewise, if the practitioner determines that the company is actually not financially distressed, then they need to terminate the business rescue proceedings as well. The business rescue practitioner, once they've been appointed, will also investigate whether there's evidence of reckless trading or fraud. And if they do find evidence of reckless trading or fraud, they will report it to the relevant authorities, and they can also direct management to take the necessary steps to rectify this. The business rescue practitioner has full management control of the company in substitution for the board of directors. So they're the ultimate authority when it comes to the running of the company. Even though that's the case, they can delegate certain functions to the pre-existing management. But by delegating the functions, they must still make sure that they are aware of what's happening with the company and that the company's affairs are being managed correctly. They can determine whether that members of the pre-existing management are not conducive to the rescuing of the business, in which case they can remove the members of the pre-existing management. And the most important function of the business rescue practitioner is to develop a business rescue plan, which they must publish to affected persons, and ultimately eventually implement that plan. So once a company is in business rescue, it basically brings about what we call a general moratorium on legal proceedings against the company. Essentially, for the duration of business rescue proceedings, no legal proceedings, including enforcement action, can be commenced with or proceeded with against the company, the property of the company, or property even if belonging to a third party in the company's lawful possession. There are some exceptions to that general moratorium. That includes if the affected person or the person who owns the property asks the business rescue practitioner to allow them to institute or commence with these proceedings, then the business rescue practitioner can give their written consent. If the business rescue practitioner doesn't want to give the written consent, the person in question can then apply to court for authority to commence the legal proceedings, notwithstanding the moratorium, or to continue with existing legal proceedings as well. And if there are criminal proceedings against a company in business rescue, then the general moratorium won't apply to those as well. Another thing to consider is that if the company in business rescue has signed a guarantee or a suretyship in favor of a third party, then for the duration of the business rescue proceedings, then that suretyship or guarantee can't be enforced against the company in business rescue unless the person who wanting to enforce the guarantee or the suretyship gets the leave of the court to do so as well. So during business rescue, the business rescue practitioner can suspend the company's obligations in terms of a contract that was concluded prior to the company being placed in business rescue, and if that obligation would become due during the course of the company's business rescue proceedings. So that suspension can be of the entire obligation, partially or conditionally. They can also apply to court to entirely, partially or conditionally to cancel any obligation of the company as well, but on terms that are just and reasonable. So that hasn't really been defined as yet, but the court will make that determination. If the business rescue practitioner suspends the company's obligations or applies to court to cancel the company's obligations, then the person, the counterparty to the contract in question, will only have a damages claim against the company, and that's prescribed in terms of the Act. But it's also important to note that even though the company goes into business rescue, employment contracts remain in place. If the business rescue practitioner wants to amend employment contracts, retrench certain employees, then they're subject to the Ordinary Labour Relations Act and employment law in South Africa. So there's protections for employees during business rescue proceedings. With regard to the company's property, as well as the property of third parties, the Act really aims to provide a lot of protection to the property interests of the company, as well as third parties during business rescue proceedings. So, for example, the company can't dispose of its property during the business rescue proceedings unless it is in the ordinary course of business. So if, for example, we previously acted for the business rescue practitioner of a property company, that the part of the business was selling the property, then in those instances, you could just dispose of the property in the ordinary course. Another instance where the company in business rescue can dispose of the property is if it's in terms of a bona fide arm's length transaction for fair value, but that transaction needs to be approved in writing by the business rescue practitioner. It can also dispose of the property if it's in terms of an approved business rescue plan. Very often, part of the plan will contemplate selling off some parts of the business of the company or their assets to get value in order to pay the creditors the dividends in terms of the plan. Okay. Most importantly for creditors, particularly secured creditors, is that if you have a security interest in respect of any property belonging to the company, then the company can't dispose of that property during the business rescue proceedings without the creditor's written consent. The only exception to that being if the disposal of that property would be sufficient to settle that creditor's claim that's secured by the property in full. So business rescue, for it to be successful, more often than not, is particularly dependent on whether the company can obtain post-commencement finance. So what we mean by post-commencement finance is generally a term to refer to finance that is provided to the company after the commencement of its business rescue proceedings. So obviously if a company is going into business rescue, it often has cash difficulties, and in order for the business rescue practitioner to have some breathing room to develop a plan to restructure the affairs of the company, they'll more often than not need some interim funding via PCF in order to allow them to do that. A lot of the time also to maybe pay the employees, get advisors on board, etc. So for PCF providers who provide post-commencement finance, the company business rescue, they can also obtain security for that, but importantly, they can only obtain security from unencumbered assets of the company. And another important consideration is that employees' remuneration, reimbursement and expenses that became due to them during the business rescue proceedings of the company are deemed to be PCF as well. So the ranking of claims in business rescue, unlike liquidation, is very contentious. There's some judgments that have come out that have put this ranking in a manner that people generally disagree with. But in terms of the Act, it has been agreed basically that the ranking is as follows. It's the remuneration and the expenses of the business rescue practitioner, including, for example, the expenses that they incur in obtaining legal services and professional services during the company's business rescue proceedings. Employees, then, for the amounts that become due and payable during the company's business rescue proceedings. Then it would be secured and unsecured PCF providers and lenders. And the next claim would be employees for amounts that became due and payable to them before the company went into business rescue. And lastly, it would be unsecured creditors and lenders. You'll note that I haven't included pre-business rescue secured creditors in this ranking, and this is because in the same way as Juliette had previously explained in liquidation proceedings, secured pre-business rescue creditors and lenders get paid in full from the proceeds of the realization of their security. And to the extent that their security is insufficient to pay their claims in full, they will become unsecured for that portion and they will rank last in terms of the order that I just explained. If the business rescue proceedings are superseded by liquidation proceedings, so for example, if the business rescue practitioner then determines that there is actually not a reasonable prospect of rescuing the company, then the order that I've just, the ranking of claims, that I've just explained will remain. The exception being that the fees and expenses of the business liquidators, normally referred to as the cost of liquidation, will rank above the claims of the business rescue practitioner. Like the in liquidation, the business liquidator has to prepare a liquidation and distribution account, which basically accounts in respect of the assets they realize. In a business rescue scenario, the most important function of a business rescue practitioner is to develop a plan for rescuing the company. And they need to do that within 25 business days of their appointment, and they need to publish the plan. So the plan essentially needs to give affected persons enough information to decide whether to accept or reject the plan, and the business rescue practitioner needs to develop this plan in consultation with all stakeholders. The Act prescribes what information needs to be in the plan in order to be sufficient to allow the creditors, the shareholders, and the employees to consider whether or not to accept or reject the plan. It's also important to note that oftentimes that time period is too short. The business rescue practitioner would need more time in order to prepare and publish the business rescue plan. If that is the case, then they can get permission from the holders of the majority of the creditors' voting interests to publish the plan at a later stage. And they can also apply to court for authority if they can't get it from the holders of the majority of the creditors' voting interests. So within 10 days of having published the plan, then the business rescue practitioner would then need to convene a meeting to consider the plan and to vote on the plan. So there will be preliminary approval of the business rescue plan if 75% of the creditors' voting interests that were voted vote in favor of approving the plan. Importantly, of that 75%, 50% need to be independent creditors' voting interests that were voted. The preliminary approval of the plan will be final approval if the plan doesn't alter the rights of any class of the company's issued securities. If the plan does alter the rights of any class of the company's issued securities, in that instance, then the class of securities whose rights were affected will need to vote on the plan, and the majority will need to vote in favor of the plan in order for the plan to have final approval. What is also important to note is that business rescue plan is binding on creditors, on the company, and on all the holders of the company's issued securities, irrespective of whether they voted in favor of the plan or not. And once the plan is approved, all the creditors cannot enforce a debt that arose prior to the company's business rescue proceedings, except to the extent that it's catered for. If the plan is rejected at the meeting, it's not the end of the process necessarily. So the business rescue practitioner can then ask for a vote to allow them to prepare and publish a revised business rescue plan, or if they deem that this is the best business rescue plan that they can present, then they can also apply to court for an order declaring the vote to have been inappropriate. If the business rescue practitioner doesn't take any of these steps, then an affected person can also do that. So they can also propose that a vote be taken to allow the business rescue practitioner to prepare and publish a revised plan, or apply to court for an order declaring the vote to having been inappropriate. Another important consideration is that a affected person or a combination of affected person can also make a binding offer to acquire the voting interests of a creditor who had voted against the plan at that meeting. And the value that is ascribed to that voting interest will be an independently assessed liquidation value of what that creditor would have received if the company had gone into liquidation. Then the business rescue will, if the plan is approved, then the business rescue practitioner will implement the plan, and the business rescue proceedings will end once the business rescue practitioner files a notice of substantial implementation of the plan. The other instances when the business rescue proceedings will end will be if the plan is proposed by the practitioner and it's rejected and no affected person applies to court to extend the proceedings, or the business rescue practitioner doesn't apply to court to extend the proceedings, or there isn't a vote in terms of which the business rescue practitioner is allowed to publish a revised plan. The court, if the company is placed in business rescue and the court sets aside the resolution having commenced the business rescue proceedings, then the business rescue proceedings will also end. And as I mentioned before, the practitioner can determine that there isn't actually a reasonable prospect of rescuing the company, in which case then the business rescue proceedings will terminate when the court makes an order converting the business rescue proceedings into liquidation proceedings. And yes, that's essentially an overview of business rescue. Are there any questions, Linda?
Okay, thank you. So we have a number of questions that actually came up during Daisy's presentation. And so yeah, one of the questions was, so how would a liquidation affect shareholders? And I think this would probably just be as opposed to creditors of the company.
Yeah, let me deal with that. So Linda, I mean, a shareholder can only get anything back at the end of a liquidation if all creditors are paid in full. So creditors need to be paid before shareholders get any return on their equity. So ultimately, the liquidation of a company generally will mean that a shareholder loses the value of their equity. To the extent that they have a shareholder loan, for instance, if they've lent money to the company, then they're just a normal creditor in respect of those amounts. And will lodge a claim and get paid however many cents in the rand creditors get. Of course, if that shareholder loan has been subordinated by agreement, so in other words, if they've agreed to back rank their claims to the claims of other creditors, then you're not going to get paid. Really, I suppose, in short, that's the effect on shareholders. They do have a role to play in terms of approving the actions of liquidators, choosing the liquidators, etc. But other than that, their role in a liquidation is very limited, because really it's creditors that a liquidation aims to look after rather than shareholders. Thanks.
Okay, thank you, Juliette. So the next question that we have is, are there any implications for directors in the event that they choose not to follow any directions that they receive from the business rescue practitioner?
Well, yes, it's important to consider that just because the company is in business rescue doesn't mean your duties as a director fall away. So the directors need to comply with the request of the business rescue practitioner and carry on with their duties, and their ordinary director's duties are still in place. So to the extent that they've breached those as well.
And then obviously to the extent that the directors don't cooperate with the business rescue practitioner, if they form part of the management of the company, he can obviously exclude them from that management role. So he could say to senior executive, for instance, you know, go home. I don't want you to be involved in the management of the business going forward. And there are, as Daisy said, also your general director's duties that you need to comply with as set out in the Companies Acts. And one of those in the Business Rescue chapter is adhering to the instructions of the Business Rescue Practitioner.
Okay. And then actually, whilst we're still on that point, I'd just like to ask about the remuneration of directors during the Business Rescue period, because I think from a ranking perspective, the priority of the company, I think, as stated by Daisy, would be to, the first priority would be to pay whatever remuneration needs to be paid to the Business Rescue Practitioner. So in relation to directors' remuneration, where would that sit in ranking?
Yeah. Well, look, remember, during Business Rescue, the company carries on business as normal, and the Business Rescue Practitioner has to pay the day-by-day expenses, and that includes the salaries due to any employee, including directors. If the Business Rescue Practitioner doesn't even have the liquidity to do that, well, then frankly, the business shouldn't be in Business Rescue. It needs to go into liquidation. So in law, obviously the directors are entitled to still earn their agreed remuneration during that period. Often what happens in practice is that the Business Rescue Practitioner will say to directors, you know, I think that you should take a reduced income during this period, and by agreement they will generally agree to it. Obviously it isn't right for directors to be earning big fat salaries under circumstances where the company is battling to pay creditors. So often by agreement directors will earn a little bit less, but they're entitled to their full salary throughout the proceedings. And if the company ends up in liquidation because the Business Rescue doesn't succeed, well, they would rank in the order of preference I set out when we spoke about ranking and liquidation. So they would be a preferent creditor in respect of assets that are not encumbered. So once secured creditors are paid from their assets, whatever assets remain, that pool of funds would be used to pay employees first before anyone else. But there is a cap on the amount that can be paid. So there's a limit to which employee claims are preferent. It's about 34,000, I think. So a director who earns a big fat salary isn't going to get all of that money in a liquidation scenario. There'll be a limit to what they get back.
Thank you for that response, Juliette. So we have another question, and the question states, how does a court assess whether a state-owned enterprise is financially distressed and should be placed under business rescue, considering its historical reliance on state guaranteed funding?
Okay, I don't know if the person asking this is thinking about SAA. I mean, look, a state-owned company, if you look at something like SAA, it's subject to the same provisions. So if it's financially distressed, it could be placed in business rescue. And at the same basis, you know, they look at the same considerations. You know, if like any company, for example, let's take a normal company. Let's not look at a state-owned enterprise. If you're a subsidiary of a big multinational group, but you're reliant on funding from your parent company, and that funding is no longer going to be available, it might mean that you're in a scenario where you need to go into business rescue or liquidation. A state-owned enterprise is the same. If there's no longer going to be funding coming from government, it might mean that you're illiquid or factually insolvent and need to be going into business rescue or liquidation. So I don't know if the person who asked that question sort of got any follow-up questions arising from that. Yeah, I'm not sure really what they were aiming at with that question. Happy to answer follow-up questions on that.
I think there was clarity from your response, Juliette, and to the extent that there are follow-ups, I'll let you know. But we do have another question. So someone asked whether a creditor can suspend or terminate providing services to a company under business rescue while the contract is still in place.
Okay, so many contracts that you have with a company will stipulate that the that the contract terminates, excuse me, in the event of business rescue. There'll often be trigger events which will terminate a contract, and in most cases, creditors have that built in, so the creditor will be able to terminate, excuse me, terminate supply. If a company is going to continue a company that's in business rescue is going to continue to deal with a creditor, the business rescue practitioner needs to be able to pay that creditor in accordance with the terms of the contract. So what was owing to that creditor when business rescue commenced, that amount will be subject to the creditor moratorium, and the creditor can't enforce payment of that. But while the company is in business rescue and continues to trade, the costs incurred by the business rescue practitioner during that process need to be serviced by him. He can't expect a creditor to keep supplying without being paid. What happens in practice is that most creditors, let's imagine, for example, I own a company, it goes into business rescue, and I've got an important IT service provider. That IT service provider's contract will probably provide that they can, stop providing a service if I'm in business rescue. And if the business rescue practitioner wants to keep using the services of that entity, they're probably going to say, well, I want you to pay in advance, or I want you to deposit money with me to ensure that I'm paid during this period. And if it's a supplier of goods, they might require cash on delivery. So business rescue can become quite an expensive process when it first goes into business rescue, because any supplier of goods or services is going to want to be certain that they'll be paid as the business rescue continues, and will demand payment upfront or cash on delivery for their products. So although they might be happy to park arrear amounts that are due going forward, they're going to need to be serviced on a day-by-day basis by that business rescue practitioner. And that's why post-commencement finance and ongoing funding becomes very critical in business rescue. The practitioner is going to need money to keep trading. And if he can't get post-commencement funding and there's no liquidity, well, I'm afraid the business rescue is never going to succeed, and the company will more than likely end up in liquidation. You on mute, Linda?
Sorry, I clicked miss. Thank you, Juliette, for that response. I think whilst we're waiting for other questions, I'd also just kind of jotted something from Daisy's presentation. She mentioned that in relation to, or the consideration for a financially distressed company, is that it will either not be able to pay its debts within the next ensuing 6 months, or whether it will fall to be, it will become insolvent within the next ensuing 6 months. So just on that insolvency point, is that a factual insolvency?
Yeah.
Or,
so it's a forward-looking test. You look 6 months in advance, and if during that period you're going to become either factually insolvent or commercially insolvent, you're a candidate for business rescue. Obviously, provided there's a prospect of the company being rescued.
okay.
So both tests apply. Yeah, it's quite strange because ordinarily what you would be critical would be liquidity, the case of ability to pay your debts going forward. But it's quite a strange provision that also allows you to go into business rescue purely by virtue of factual insolvency as well.
Okay, thank you, Juliette.
I just see typed there, Letty, who'd asked a previous question about the ability to suspend or terminate contracts. She says, thank you for saying, and then she wants me to clarify that the provision in a contract that allows for termination if a company goes under business rescue can be enforced. And yes, that can be enforced.
Okay, we don't have any other questions. I don't know if I can ask one last question. I promise this is the question from So Daisy, you mentioned that for the adoption of the business rescue plan, I think about 75% of the creditors need to agree to it. Are those creditors in numbers, or creditors in deal value in relation to the loans that they have with the company?
It's value. So it's 75% of the creditor's voting interest. So you might find that one creditor, for example, makes up 25% of that 75% because of their claim. So the value, the voting interests are determined by the value of your claim as against the company.
Yeah, it's like a 1 rand, 1 vote system. So if you own Rand, you have 100 votes. If you owed R1, you have 1 vote. And it's 70, you need 75% to get it through.
Yes, and 50%
you have 20. Yeah, and if you have 20, so it means that if you have a claim that's 25% of the value of creditors, you can effectively block a plan.
Okay. We did get one more question from Toby. So Toby says, in practice, what happens when the process requires court intervention, but there are court delays? Does everyone carry on acting in the best interests of the company and hope for the court's condemnation, as otherwise there will be a value erosion?
I don't know if he's asking about liquidation or a business rescue scenario. Both in business rescue and liquidation, though, generally the court will accept that whatever application is before it is urgent. So you can get into court a lot quicker and have the matter resolved quite quickly. So there shouldn't be very long delays. In circumstances where there are delays, of course, yes. I mean, whoever's in charge, if it's the liquidator or the business rescue practitioner, has to continue to carry out his duties as efficiently and carefully as possible to ensure that there isn't any value erosion. But for example, in a business rescue, if litigation is going to cause huge delays, that can be a big problem because the company might start losing the liquidity it requires to keep trading. So it might have been able to get a certain amount of post-commencement finance from a shareholder or a bank, for instance. But if the company is going to have to keep trading for ages as a result of litigation that's causing problems, that money could run out. So that, of course, would be a reason to try and get into court as quickly as possible. And that's where our courts are not always ideal. Our courts aren't designed for always resolving disputes urgently. And you can have situations where delays do start to cause problems.
Okay, so Juliette, just in an effort to redirect the conversation to I think the most pertinent consideration for today, all of this information that we have now, how do we apply that to small businesses? So I mean, how can you practically implement either a business rescue procedure or well, I guess liquidation you could, but I think particularly with business rescue, how much of an interest is there to rescue small businesses? And yeah, so just in relation to maybe like the number of employees, like a business that wouldn't even be big enough to have a union represents their employees. Maybe you have like 3 employees. Can you get a business rescue practitioner appointed?
Yeah, look, I mean, in theory, business rescue can apply to any size business. It will really depend on the profile of that business and what people want to achieve. There is no doubt, however, that business rescue does have costs associated with it. So, for example, you need to be paying the fees of a business rescue practitioner. How a business rescue practitioner charges is on an hourly basis. There's a set tariff. And it's not a particularly high hourly rate if you look at the fees that most professionals would charge, but nevertheless, there are costs. And then, as I mentioned also, when a company goes into business rescue, inevitably, there are a lot of creditors who want to be paid up front going forward or cash on delivery. So there's a liquidity problem that can often arise. So there are a lot of costs that you have to be able to fund up front. But if it's, for example, a very small business, Linda, but it's got a shareholder who's willing to fund the business through the process and then use the process, for example, to compromise its debts with creditors. So, for example, to pay creditors 20 cents in the rand and therefore get rid of a huge big debt burden that's sitting over the company, and creditors are willing to go along with that, you may be able to achieve a successful business rescue. So it's really not linked to the size of the company. It's more linked to the prospects of getting a plan through, having the requisite support of your creditors. And, at the moment, especially with what's going on in the country, creditors out there, understand and will generally be supportive of a process if they feel it's done fairly and transparently. In many cases, they'd rather have a customer or a client going forward who they can continue to trade with than lose that business entirely. So if it means taking a little bit of a hit now to have a good customer or client or service provider or whatever going forward, they might be willing to support that process. The banks likewise are being as supportive as possible at the moment. So there are instances where business rescue works for small companies. It's just a question really of the funding to get it through that process. And also the other thing I want to mention is that, as Daisy explained, during business rescue, you need to go through the normal retrenchment processes, etc., with employees. So if you are going to try and undertake a big retrenchment process during business rescue, that will be quite expensive. You've got to fund it. And that can sometimes be a hurdle that a business just can't get over. If they're wanting to retrench many, many employees, it might then dictate that rather the business actually just has to go into liquidation.
Okay, thank you. Thank you, Juliette. We have another question. So someone asked, if they're doing business for the first time with the company, is it mandatory for that company to declare if they are in business rescue? And I guess that mandatory is probably in relation to any legal requirement that the company might have to disclose that.
Yeah, look, the company should make it very clear that it's in business rescue. So anywhere the name of the company appears, it should be, Joe Blogs, Pty Limited, in business rescue. And also you should be dealing with the business rescue practitioners rather than normal management. Although, I mean, certain things can be delegated to the usual management, but it should be very clear from the company's letterhead, from their website, etc., that they're in business rescue. And it would be highly questionable if they didn't make it clear that they were in business rescue.
And then we have another question that states, what is the difference between business rescue and the Section 155 compromise procedure in the Companies Act, and how can small businesses take advantage of the compromise procedure?
Okay, so a Section 155 compromise is another way that one can restructure a company. Similarly to business rescue, it involves putting together a proposal that creditors vote on, and if 75% of, it's essentially if your requisite percentage of creditors agree to go with that proposal, it's binding on all creditors. The big difference between a 155 compromise and a business rescue is that until a 155 compromise is implemented, there's no creditor moratorium. So during the period that the company is trying to negotiate with its creditors, any creditor can scupper the whole process by instituting proceedings or bringing a liquidation application. That, in contrast with business rescue, where the moment you're in business rescue, there's this moratorium and this freezing, and the company gets this breathing space to try and make a plan. And that's often what makes a 155 quite tricky, because you need to have all your creditors cooperating with you on a bilateral basis. Just one uncooperative creditor can mess up the whole process. But if you have a small group of creditors, all of whom are willing to agree to a process and cooperate, you can do a 155 compromise. And again, it's a process whereby you can end up creditors agreeing with the company to accept 10 cents in the rand or 20 cents in the rand. It's a sort of a more informal process. It's also something that liquidators sometimes use. You could have a company in liquidation coming out of liquidation through a 155 compromise. That does happen sometimes. One thing to mention is that if a company is already in business rescue, you can't do a 155 compromise. I don't want to go into too much technical detail about 155s. We could do a separate topic on that, but really it's akin to a business rescue, but without that moratorium, and without there being the supervision of an external person like a business rescue practitioner. So management would remain in control. It's just very tricky to do if you have a big body of creditors who aren't cooperating. You'd normally want the protection of the moratorium that the business rescue gives you.
Okay, so that was the final question on my end. I think it's been quite an informative discussion and a very constructive one as well. We've had a lot of engagement from all of our attendees, and we had very informative presentations from both Daisy and Juliette. And we also appreciate your ability to answer all of these sporadic requirements for you to you know, have a very in-depth on knowledge on the technicalities around liquidation and business rescue. So I think with that, we can probably conclude the session on that note. To the extent that there's probably any feedback or requirement for more information, please just email anyone at Bowmans. And also please note that we will have this presentation available on the website for anyone to revisit at a later stage in the event that you want to revisit some information, or for anyone else who would have wanted to attend but couldn't. But thank you very much, Juliette. Thank you, Daisy. I thoroughly enjoyed that. I think everyone on the panel and the attendees enjoyed that as well. And thank you to all of the attendees for taking time out on their day to listen to your presentations.
Thank you. And if anyone wants to contact us, our details are on the Bowmans website, both Daisy's and mine, if they want to email us directly. Thanks.
Cool. All right.
Thank you, everybody, and goodbye.
Thank you, everyone. Cheers.